SJC-13793 in the matter of an impounded case.
Attorney Toomey.
Morning, Chief Justice, Associate Justices. May it please the court, Dennis Toomey on behalf of the juvenile. Trial prosecutor argued the juvenile reposted the meme to be funny as humor for his peers. The juvenile said it was done accidentally. But either way, this case is about a child who merely pressed a button without writing any words and without being aware that anyone else would think reposting someone else's popular meme would be considered a threat to the juvenile's own school. More should be required to prove this serious charge. I'd like to focus today on the state of the evidence because it drives the outcome for two of my primary claims, that being insufficiency of the evidence at trial and the prejudice from the absence of a jury instruction on the subjective intent element. As to subjective intent, Cruz and Counterman tell us that there should be an element for any type of threat case.
You got to win on that, right? They concede.
Yes, they concede as to the instructional error, but they do not concede as to sufficiency of the evidence for that. That's what I'd like to focus on. Again, this is a child who pressed a button with no eyewitnesses.
The sufficiency argument, it seems to me, goes to the willfulness part of it, that it was an accident as opposed to the effect on others, which is the subjective part.
Well, I've raised 4 insufficiency claims. Number 1 is that they didn't disprove accident. Number 2 is that they didn't prove it was a true threat rather than humor, which is protected speech. Number 3, they didn't prove that this juvenile adopted the meme's messaging as his own willful communication. And number 4, they didn't prove that he was subjectively aware that others would think that this meme was an actual threat to the juvenile school. So I think
that they can, that in assessing the sufficiency of the evidence, the contents of the message itself can be considered?
yes.
All right, so then it seems to me that why aren't we purely in the realm of the jury's province? Because this message, it seems to me all the things that you are arguing were insufficiently proved might be able to be proved by reasonable inferences from the message itself.
Well, I think that this court reviews the evidence in the light most favorable to the Commonwealth, but the fact that the jury found the elements proven, except for the subjective intent element, which they were not instructed on, that does not mean that the evidence was actually sufficient.
I'm not saying that. And I'm sorry if my question suggested that. My question is, if we can look to the contents of the message itself to draw reasonable inferences about what may have been in the juvenile's mind when he reposted it, why is the evidence not sufficient?
I think it would require speculation to try to get into the juvenile's mind as to what he was thinking at the time that he reposted. Again,
We do that all the time. We usually don't have direct evidence of what's in somebody's mind. We look at what the circumstances of the reposting are.
That's correct, but there is no other evidence except that he reposted it and that he told police he did so
Well,
accidentally.
there's the content of the message.
Correct, but we're dealing with a child here. As we know, children are much more likely to act impulsively and not consciously consider the consequences of their actions. So even if you were to disbelieve the juvenile that he posted accidentally, which there's no contrary evidence of, but even if you were to discredit that claim, there's no evidence besides pressing the button. The fact that the meme, the words on the meme, that does not mean that this juvenile was adopting them as his own willful threat.
These just things that the jury.
Right. Are these jury questions?
There has to be some additional evidence besides pushing a
long
button.
Well, I mean, when I was reading on my iPad and I clicked the page, it's kind of startling when you look at the meme. It's frightening.
I think that the
In and of
fact
itself,
that
that it's done is-
the fact that someone else like yourself or the witness were allegedly frightened by it, that does not mean the juvenile was aware of that fact. I mean, TikTok encourages children to share and repost anything they think is interesting. So kids do not always stop to think, is this actually a threat? Is this scary to someone else?
I think that my reaction goes to what Justice Wolhogen said is, can't we look at the contents of the meme itself And the jury can consider all this and to see what effect it would have on people who receive it.
I think that would only then go to the objective true threat analysis. I don't think the effect on other people has any bearing on the subjective intent element.
That's why you're going to get a new trial.
But at what point does reposting something that is objectively dangerous, at what point does reposting that kind of imagery cross into recklessness, though?
I look towards this court's model instruction in Cruz to say that there has to be proof that the juvenile was subjectively aware before he pressed the button of how others would react to this.
Well, I think that goes back to Justice Wolahojan's point. I mean, if you can look, and actually Justice Gaziano's point, you can look at it in and of itself and say, you couldn't possibly reasonably expect that anything but somebody was going to take this seriously. In this day and age.
I don't agree when we're talking about children and social media. I just think the reality is that children press share and repost without thinking. So I don't think that the meme itself proves subjective intent. I think there has to be some additional evidence. For example, if the juvenile had personalized the message or sent it directly to his teacher or said, the name of his school in the caption or something like that, but there was no words at all. He left the author of the meme's name, Paxton, on the meme itself. He gave credit to them. He merely reposted someone else's work. What kids do typically when they're doing that is they're saying to their peers, look at this. They're not saying, I adopt this as my literal language and I'm going to do this.
But that changes the framework then, because that's in the light most favorable to you. And that's not what we're doing here. You're free to argue all that at trial, but in the light most favorable to the government, right? We don't look at all of that.
I agree, but I don't think you can say anyone who reposts this meme absolutely is aware that it would be threatening.
Well, that's the test is not subjectively aware. It's whether the juvenile consciously disregarded a substantial risk that others would consider the statement to be a true threat.
Absolutely, and consciously disregarded, I think, is the key phrase there. When children repost things, and we're not even getting to the factor of, of a neurodivergent child, just children in general, when they repost things, they do not always consciously regard the consequences.
That's the key there. They do not always consciously disregard, but some do.
Absolutely.
Therein lies the jury question, and therein lies what Justice Gaziano was pointing out, or Justice Georges was pointing out, that that's something that you can argue to the jury. Our question was, in the light most favorable to the Commonwealth, did they adduce sufficient evidence to merit a new trial on this subjective intent element?
And my only answer, again, is that there has to be some additional evidence.
So as a matter of law, you're suggesting that the post itself and the reposting of the post could not meet the standard of consciously disregarding a substantial risk. That no child could, having reposted this, be found to have consciously disregarded a substantial risk that others would consider the statement to be threatening.
Yes, my answer is that if we're dealing with a child reposting someone else's meme, there has to be some additional evidence. The meme itself does not prove
What's
it's
your
subjective.
best legal authority for that proposition?
I would.
So what if I reposted it, an adult? Does that meet the recklessness standard? Are we making a unique rule for juveniles?
No, I think still in every case you have to look at the circumstances. So depending on the meme and depending on what facts were introduced about you personally at trial, that would go to whether the Commonwealth proved.
But what if it was just the same facts? It's just that I'm in my 50s and he's not.
If I were representing you, I would still argue that this was insufficient if you merely reposted a meme with no words.
No, as a matter of law, you would say a directed verdict or whatever it is.
Yes, if there was.
We've rejected the reasonable juvenile argument in other contexts. Are you asking us to do,
No.
to oppose reasonable juvenile standard here?
No, I'm not asking for any sort of blanket rule or specific juvenile rule. I'm just arguing that the evidence as to this particular child at this particular trial was insufficient to prove his subjective intent or his awareness that others would deem this to be.
Can you address I mean, obviously, we don't just have the meme here. We also have his statement to police that he has a, quote, dark sense of humor, unquote, and what the Commonwealth has argued is consciousness of guilt evidence that he deleted the post or deleted the post, essentially. So can you address those, please?
Absolutely. So that goes to subjective intent and also to the failure to disprove accident. But he did tell police that he took down the repost as soon as he realized he had accidentally reposted it. But that's what someone would rationally do. If you or I accidentally hit a button on our phone, we would delete it. So I don't think that's proof.
But you have to view the evidence in the light most favorable to the Commonwealth. So viewing it in the light most favorable to the Commonwealth, why is not the reference to the dark sense of humor and plus the deleting it? Do you agree that that adds some weight to the argument on the counterman element?
No, only because the fact that he deleted it only, if any, goes to his state of mind at the time he deleted it. It does not prove he was subjectively aware at the time he reposted it. So perhaps he realized afterwards that, if you're discrediting accident, that that it shouldn't have been reposted. But that doesn't mean he had that conscious awareness at the time he reposted.
Not as a matter of law, but isn't it possible the jury to conclude that?
I think it rests too much on speculation and conjecture when there's no other evidence here. Again, if the
I
police
thought he didn't delete it immediately. When did he delete it?
The police officer did not testify as to the exact moment in time, but he did testify that it was not on the phone any longer when he met with the police 4 days after.
I thought there was some evidence that he deleted it not immediately, that he deleted it maybe the following day. Am I misremembering? It's entirely possible I'm misremembering.
I don't believe the specific date was included in the statement to the police, but we can reasonably infer that it was sometime between when it was reposted and when police went to his house a few
Within
days
4
later.
days.
But again, whenever he deleted it, that's not proof that he had subjective awareness or an intent.
But it might bear on whether it was an accident, because a jury could conclude that if someone deleted something instantly after posting it, that would make it more likely that the person had posted it by accident, rather than if he waited a day or two and then deleted it, which would be less likely to support an inference that the initial posting was by accident.
Well, I think that analysis still requires a lot of conjecture. And even if he deleted it a day later, that could have been the next time he logged on to the TikTok app and noticed on his page, whoa, I meant to click not interested, a button that if you click the arrow, by the way, if you look at the exhibit at A38, if you click the arrow on the bottom of the TikTok app, it brings up a screen with 30 buttons, 2 of which are not interested and repost. They're near each other. So accident was claimed, it was certainly plausible, and there was no contrary evidence to disprove accident.
I'm still wondering how to square your argument with the sufficiency standard, because all of the things that you point to, that there's no evidence that anyone saw the contemporaneous awareness of the posting, that he explained that it was accidental, deletion cuts against intent, his dark sense of humor, all of those seem to be trial defenses to culpability. And I just, how do we make that determination under the framework of in the light most favorable to the government?
Even in the light most favorable to the government, and again, their theory was that he did it as an attempt at humor, which does not, I argue, does not satisfy the subjective intent element. So their own theory at trial doesn't satisfy it under the true threat objective standard or the subjective intent standard. But there has to be something more. I don't think you can speculate what did you...
Well, then give me that then. What other facts should be present? I know you mentioned one, like you got to do something to co-sign this or something like that, I approve this message or whatever it is. But what else should we be looking to, or what else in your research should be accompanying this kind of reposting to suggest that you can get over the recklessness standard encounterment?
Yeah, I think that there needs to be some other evidence, whether it's personalizing it to your own school, which would make it more seriously. If you had prior bad acts of that regard or something like that, there has to be some other piece. Perhaps it doesn't have to be a large piece, but something to take reposting someone else's meme to personalizing it to your own threat. Because otherwise you're just sharing and showing someone else what someone else was saying. That cannot be enough when we're dealing with children. Impulsive, neurodivergent children, that cannot be enough to prove that this was subjectively an intentional threat to disprove accident, to prove that he willfully adopted someone else's meme language, which he didn't write, as his own threat. I can see my time is running short. Justice was not done for this juvenile. If there's no further questions, I'll rest my brief. Thank you.
Okay, Attorney Spate.
Good morning. May it please the court, Hallie White, Spade Assistant District Attorney for Middlesex on behalf of the Commonwealth. Before moving on to the sufficiency arguments, I just want to note for the court, obviously the Commonwealth agrees that counterman applies to the bomb hijack statute. There's absolutely no principled reason for suggesting that if it applied in Cruz, it shouldn't apply here. To the extent that the juvenile and the amici are asking for special juvenile-centric definitions for the intent element or special juvenile-centric jury instructions, which I believe are proposed in the amicus brief, there's no basis for that. There's no reason for it. The arguments they're setting forth are the reasons why the juvenile justice system is different in the first place. And, you know, if those definitions and those instructions apply here, why wouldn't they apply to any offense charged in the juvenile course? The error was not preserved. There's absolutely no argument for the mens rea set forth in counterman to be applied here. Nobody at this trial seems to have been aware of counterman, and this is embarrassing to me personally. But absolutely nobody seemed to think that this was necessary.
Well, it was raised in the defendant's original motion, was it not?
No.
Counterman was literally cited.
In the motion to dismiss?
In the motion to dismiss, it literally cited counterman. I don't have the record citation here, but I think this exact. I think that the Commonwealth concedes that the Commonwealth is arguing that.
Kearns is cited.
It's in the record appendix on page 27. The U.S. Supreme Court has defined true threats as serious expressions conveying that the speaker means to commit unlawful violence. See counterman.
I'm sorry, I'm not. My record appendix pages are not numbered, which is bizarre.
So this is in the Commonwealth's memorandum in support of the motion to dismiss on the. I don't have the page numbers of the memorandum. 1, 2, 3, 4, 5 on the 5th page of the memo in support of.
Oh, I see. There it is. Yeah.
I don't think it really. I'm not sure how important it is.
Okay. Yeah. Okay. I see that. That's interesting. I missed that. It's not a clear assertion that. And certainly at trial in the charge conference, there is no request for a counterman style mens rea instruction. So to the extent that this is cited, I don't think that's sufficient to raise the issue. Certainly not to raise an issue with regard to a jury instruction. That said, it is not preserved. Even if it is, this court finds that it is preserved, which we don't concede, the amount of daylight between harmless beyond a reasonable doubt and substantial risk in this particular context is very, very small. And, you know, this court is certainly able to decide whether it survives.
Is the Commonwealth arguing that, on the sufficiency question, is the Commonwealth arguing that on the basis of the meme alone, the evidence is sufficient?
No. I mean, the content of the meme is certainly important and is certainly something you can consider. The fact that it is reposted with no disclaimer, no qualification, no, gee, isn't this funny? Gee, I hope this doesn't happen at my school. Wow, this guy's crazy. That a first-person meme is reposted without commentary is, again, something the court can consider. That the person who reposted the meme is a student in a high school in a country where 20 years ago this court took
Not-
judicial notice of school shootings.
That wasn't, evidence was not before the jury about.
Okay, that was not before the jury.
So can you just, sticking to the record, like
But
what?
that he is a student in a high school. That school shootings are a serious threat.
But
And
that's
that's
part of the record?
inferable. It's the police officer testified that he talked to him about school shootings and how this is taken seriously. And I think that's sufficient. I don't think we have to put in, it's something that a court could take judicial notice of, certainly. But that was not requested here. But that he is a student in a high school, this is it's common knowledge. That he said he had a dark sense of humor, I think that phrase does an awful lot of work here. And I don't know another way to understand that than to say, I get that people might find this upsetting. I don't know how else you can read that. So you put all of that together, and I think it's entirely sufficient. There was extensive testimony
Can you address
about
the chilling effect that this, a rule that what you've just delineated is sufficient might have on the First Amendment exercise? That one cannot have a dark sense of humor and post something about school shootings that are prevalent in our society
I think
as a joke and jest, and have it end up on their profile page on TikTok, not blasted out to the universe, but instead somebody needs to go to their space and find it and view it. What kind of chilling effect would that have? Well, just has the government thought about that at all?
I think given the menacing nature of this particular post, that's not a particular concern.
So there are thousands of, I don't remember the exact number, but this was reposted very, very, very many times. And we can assume that many of those people were high school students given the content of the meme. So are you saying they're all guilty of this statute?
I'm saying, I'm not saying they're all guilty of that.
So what would be
I'm saying-
enough?
I'm
You're
saying
saying
that
what
this could-
reposting it is enough.
And I'm not saying the fact of the repost by itself, the fact of the repost by somebody, and again, this was not in evidence at trial, but it is in the record, someone who had a history of
I think it's
threats.
really important that we stick to the evidence at trial, that the whole question is whether the juvenile can be tried again. And so we are very much confined to the evidence at trial.
I think in the light most favorable to the Commonwealth, yes.
So in the light most favorable to the Commonwealth, can you respond, because I may have interrupted you, to Justice Wetland's question about, is the view of the Commonwealth that any child who reposts a meme like this can be prosecuted for this crime?
I mean, I think as a matter of law, yes, every case is different and every case should be judged from its own facts.
Yeah. What about the kids who liked it? Can they be prosecuted? Is there a difference between liking something and reposting it?
I think, well, that's an
Not as a
interesting question.
technical matter, but from the government's perspective, could all of those people who liked it also be prosecuted for violating the statute?
No.
Why? What's the
Because
difference?
I think the repost is an act of communication.
Liking is an act of
It's a
communication.
dissemination in a way that liking is.
How is it different?
So,
How is it different?
it's a very fine distinction.
It is, and we're talking about sufficiency in the light most favorable to the Commonwealth. Aren't those finities counsel in favor of the Commonwealth then?
I think to frame something as a communication coming from your own account. This is me. I just as
This is me liking this meme.
liking this is different from this is me saying this.
Well, they're not saying it, they're reposting it.
That's a way of saying it.
Isn't liking something a way of saying I like this kind of thing?
I like this is different from I say this.
Why? What's the difference?
Because I like this is the me in the meme is not me. I like this is this person said that.
But people,
And I think it's funny.
people repost things
I
out of
repost it. It says, but I mean, my own social media footprint is minimal, but an awful lot of people that I follow on social media have a line in their bio that says, repost does not equal endorsement. And this tells me that there is an assumption out there that reposting something means endorsing it. And I think that that's a reasonable, in the light most favorable to the Commonwealth, a reasonable interpretation of that. The fact that not everybody who reposts something and not everybody who likes something is going to be prosecuted, which as a practical matter is the case, does not mean that this person in these circumstances who reposted this meme could not be prosecuted.
That's why I focused my question on the chilling effect that this might have, which was, as you know, the focus of the decision in California.
I understand that, yeah.
But here
Does
we
seem to leave a lot of worry.
It is a reasonable concern, but I don't think we're there with this particular image.
But in this case also, there was, in the sufficiency calculus, we had reactionary evidence too,
Exactly,
right?
yes.
And was it just I guess the former partner? Was there also other members of the school or other?
There is no evidence of any other reaction from anyone in the school. But the girl who testified was frightened by it because she knew.
The girl who testified to it went looking for this child's TikTok account.
But it's a public account.
It was a public account, which is why she had access, and then had to open whatever he reposted on his profile page in order to view it, right? It wasn't, she didn't see it because she has a TikTok account.
She did. She could see it because she had a TikTok account.
No. It wasn't because she opened TikTok and suddenly it came up.
It didn't come up on her feed
reposted
because she was not friends with him on TikTok.
Yes.
She didn't
She had
follow
to go
him.
find him.
She went to find his profile page, but anyone with a TikTok account can see his profile page.
Yes.
I mean, no, it wasn't on a billboard on the Mass Pike. But there seemed to be this argument at trial, which I think was deeply misguided, that she somehow hacked into his account and could see it only because
I understand how TikTok works. I'm just, again, my concern is the First Amendment, if you could let me finish. My concern is the First Amendment aspects of this level of liability for somebody liking or reposting something that, that others might subsequently consider dangerous.
I understand the concern. And it is an entirely legitimate concern. I think in this day and age, given the nature of this post, I'm less concerned with children.
What was the evidence at trial concerning when the girl saw the post?
She testified that she saw it, and I don't have the dates to hand. And there was some dispute about how long it took her to report this to her mother and to get it reported.
I'm not
to the
worried
school.
about how long it took her.
But after it was posted, it's not, after the original
know
post?
which day? Do we know the timing relative to the time the juvenile reposted the message?
I was looking for that, and I don't think there is anything about that. She did not testify to any timestamp on his post.
Do we know the day?
The date that
The day that she saw it and the day that he reposted it?
she saw it on December 7th, and there was no evidence that I know of, and I can't see it on the screenshot of when he posted it. It was up long enough for her to see it, but we don't know how.
It could have been.
It could have been an hour before. No, we don't know.
Right.
But it was certainly gone by the time the police became involved. And we don't know when it was taken down either.
Can we just, without meaning to suggest in any way that it displaces the need for the counterman element, could you please address the juvenile's argument that the willfulness has to cover not just the word threat, but which prong, like what kind of threat it is? That does the Commonwealth have to prove that the person willfully communicated a threat that such and such, or only willfully communicated a threat?
I think I think the normal reading of the words of the statute is that willful applies to communicates or causes to be communicated. Because it's not, it's threat is then the object of communicates or causes to be communicated. And so I think it's clear that that willfulness applies only to the communication.
Isn't that the opposite of what we said in the recent Russo case?
I don't think so. I'd have to look, but I don't think so. But in any event, Counterman makes clear that the threat has to be either intentional or he has to be consciously aware of it. I could take 12 seconds to address the claims of error at trial, but I think the court can sort those out. So I'll rely on my brief. If there are no other questions, ask the court to